Hello everyone, welcome to part one recording of a series of general defences. The first one we're going to look at is insanity. So insanity is a general defence, which essentially means it can be raised to counter liability for all crimes. It's not really limited in the crimes that it can be raised for. Historically, it was developed and used quite commonly to counter liability for murder. And that's because being convicted of murder used to bring the death penalty. And so defendants to escape the death penalty would claim that they were suffering from insanity at the time of the offence. And what that would lead to would be detention in a secure hospital instead of being hanged. So it was quite a commonly used defence until the late 1950s when the Homicide Act was introduced and diminished responsibility and provocation were brought in. As you know, these are not general defences, but they are specific defences to murder. And diminished responsibility, by and large, replaced insanity where murder was concerned. And when we look at the test for insanity, you'll hopefully be able to draw similarities between insanity and the old diminished responsibility. Of course, we know it was updated in the Coroners and Justice Act 2009, but the first test for diminished responsibility is very similar to this. So historically, it was very popular, but not so much now. And part of that as well is the terminology. Nobody wants to be labelled as insane. If you're found to be insane by a criminal court, then the verdict that you would be given, the special verdict, would be this one here, not guilty by reason of insanity. And that actually comes from the Trial of Lunatics Act, 1883. So you can see the terminology is just not fit for modern times. So it does give rise to a lot of criticism in an essay question as well. So what we're going to do in this session is just have a look at the defence and identify the test. For the purposes of your OCR exam, you would need to be able to apply the test of insanity to crimes, as I say, less so for murder, but as it's a general defence, it can be raised for any crime. So you could be considering insanity in a theft scenario, for example, or a robbery, burglary scenario, non-fatal offences, and we'll have a look at a little bit of application later. If you raise insanity, what you're saying is that you were unable to, certainly, first of all, commit a voluntary act. We know the principles of criminal liability. An actus reus for someone to be guilty has to be voluntary. And by nature of insanity, you're not committing a voluntary act because you don't believe you are, if you like, you don't understand the nature of your act. So the actus reus is not formed, but also it does refer to your state of mind, insanity. So you're saying as well that you can't form the mens rea. You haven't got the intention to commit the particular crime, or even the recklessness, the realisation of the risk. Or if it's theft, you can't form dishonesty, if you like. You don't understand that your conduct is dishonest, and therefore ordinary and decent people may not view your conduct as dishonest if they knew of your state of mind. But of course, if you are being judged against the ordinary and decent person, there will be question marks raised over the application of those tests to people with mental health. There will be criticisms there. So the defence is available to all offences, but those that require actus reus and mens rea. So if you are charged with a strict liability offence, one which doesn't require mens rea, as in the case of Harper, where he was charged with drink driving, essentially a crime called excess alcohol, then he would be unsuccessful because that crime does not require any mens rea to have been formed. It is purely a strict liability offence. So, as I say, it focuses on the mental capacity of a defendant. And the question in deciding whether to deliver the verdict we've looked at is, are they fit to stand trial? And the jury make this decision in a Crown Court, interestingly, and they are told to make this decision based on medical evidence, and also looking at whether the defendant is able to do a number of things. These are called the 6 capabilities. So they have to decide whether the defendant understands the charge, whether the defendant is able to enter a plea of guilty or not guilty, whether they're able to challenge jurors. So if you go back to the jury selection process, the defence team can challenge the selection of a jury by array or for cause, whether they can instruct counsel or solicitors, whether they can follow proceedings, so can they follow the course of the trial, and whether they're able to give evidence if they want to. Of course, they don't have to, but whether they are able to. So these are the 6 capabilities. They come from originally a case called Pritchard. And the jury are making this decision on the balance of probabilities, so essentially a civil standard of proof, which is quite interesting, seeing as this defence relates to criminal proceedings. We once again have an overlap of civil and criminal. If they decide that the defendant cannot do these things, then they are going to be delivering that verdict. The defence is unique in that it can be raised by any legal party. So it's not one that is just reserved to the defence to raise. A judge could raise it. The prosecution could raise it. The prosecution can't accept a plea of insanity, as they would often do with the defence. They'll often plea bargain, if you like. We will accept manslaughter instead of murder, for example. But they can't do that with insanity. There has to be a finding and the proper procedure followed. The problem with this defence being raised by any party is that the defence might be raised against a defendant's will, and they might not want to be labelled as insane. And what can happen is that defendant will just plead guilty to the crime to avoid any insanity proceedings, which can potentially result in an unfair trial, as we will see in a few slides' time. So the end result is going to be the special verdict, and what comes with that is an order for either detention in a secure mental hospital, or since 1991, the orders are wider. You can be given treatment in the community. So you could be given a guardianship order, some kind of rehabilitation order. The whole point of insanity is that it's recognising that somebody is suffering from a condition that needs treatment, and it's likely to happen again. So this defence is not about, if you're successful walking away as a defendant, that is very unlikely to happen. This is about recognising that that person needs treatment and ordering that treatment. It's an order of the court. So it's unique in that it's not really, if you're successful, it doesn't operate in the same way as other defences. Its counterpart, automatism, if you're successful in automatism, having committed an involuntary action with no mens rea as well, you would get to walk away. And often defendants want to raise automatism because they like that idea. They want to walk away with no orders hanging over them. But courts will always look at, when faced with automatism or insanity, they will always look at what the condition is and whether it gives rise to treatment. Does this defendant need treatment? Is their condition likely to reoccur? If they believe it is, then they will deliver a finding of insanity instead. Okay, so as I say, insanity's been around for a long time, and the test to which the courts determine whether somebody is suffering from insanity at the time of committing the crime comes from the leading case of Mannen, and note the spelling as well. So this was a defendant who suffered from paranoia and thought he was being persecuted by the government, so labelled, treated unfairly, plotted to kill the Prime Minister but ended up killing the Secretary instead. It was evidenced at trial that he was insane, and therefore he escaped the death penalty. There was a huge public outcry about this. The significance of this case is that the test was formed, if you like. So the starting point is that the defendant is presumed sane unless at the time of the offence it can be proven that they were suffering from a defect of reason which was caused by a disease of the mind, which caused the defendant not to know the nature and quality of their act, or if they did, not to know what they were doing was legally wrong. So just have a pause and think about the old diminished responsibility test, which was brought in 1957, and see whether you believe that there are similarities here to this test. And what we're going to do is look at each strand at a time. So what do the courts mean by a defect of reason? Essentially, the defendant must have no powers to reason at that time. So this isn't going to cover those defendants who have a period of forgetfulness or absent-mindedness. So the courts will have a look at the basis and the length of time that the defendant was unable to reason. And the leading case on this is a case of Clark, which is a theft case. This involved a 58-year-old woman who placed a number of items into her bag while shopping in a supermarket. She had no recollection of doing this. At the trial, it was raised that she was suffering from depression and also she was diabetic. And this may have been the cause of absent-mindedness, if you like, at the trial. The judge at trial ruled that this appeared to be a case of insanity and wanted to explore it more. Clark didn't want to be labelled as insane, so quickly changed her plea to guilty to avoid a trial and was convicted. What she then did was appealed to the Court of Appeal against the judge's ruling, and the Court of Appeal agreed with her. They said that her short period of absent-mindedness or confusion did not amount to the defect of reason. It fell far short of what is meant by a defect of reason. So there you go. If it's a short period, it's not going to be a defect of reason. Of course, there is still some open interpretation of that. Every case is decided on its own facts. It cannot be somebody who suffers a temporary episode of forgetfulness or absent-mindedness. What do we mean by a disease of the mind? There is some criticism, and if you look on the Crown Prosecution Service website, they will also make reference to this. This term is a legal term. It is not a medical term. It's not one that doctors would certainly even use now. But there are a number of conditions that have been classed as a disease of the mind, and we will look at those shortly. Now, a court will hear from medical experts in determining whether somebody is suffering from insanity at the time, but ultimately they will then decide whether that constitutes a disease of the mind, having looked at their 6 capabilities too. So we obviously have Mannen, delusional states, paranoia, but it does widen. It does stem to also those conditions that would appear to be physical too. And Kemp was a really good illustration of this, where the defendant suffered from a condition that had primarily physical effects. So he suffered from arteriosclerosis, essentially hardening of the arteries, And there was an episode where he lost control and attacked his wife with a hammer. There was no evidence brought to light that he had any motive to attack his wife. They had a very happy relationship on all accounts. So this really was not in dispute that it happened as a result of his condition. The courts actually held that this gave rise to insanity because they said although it was a physical condition, the condition affected his mind, his memory, his ability to understand and reason in that particular time. So they deemed him to be suffering from insanity at the time. So it just shows you how wide that it can be. The third part of the test is that the defendant must not know the nature and quality of their actions at the time, or if they did, they must not know that the act was legally wrong. So the page, there's just a little activity. So if you can pause here and just tick whether you think in each of these very far-fetched scenarios, the defendant knew the quality of their act, so they knew what they were doing, or if they knew it was legally wrong. And I wonder whether you can identify which defendants would be unsuccessful because they appear to know the nature and quality of their act and to know what they were doing was legally wrong. So pause there, please, and see if you can complete this. So hopefully you've identified that certainly defendants at number 2 and number 5 would be unlikely to be successful in raising insanity because they appear to know the quality of their action and to know that it was legally wrong too. Certainly with number 5, even though you might believe something is morally the right thing to do, you could still believe that it is legally wrong. You know, legally wrong and morally wrong aren't always going to match up. There is a case example of a defendant who was proven that he knew what he had done and that what he had done was legally wrong because of what he said when he was arrested by the police. So the defendant killed his wife, and when he was arrested, he said to the police, "I suppose they will hang me for this." So when he tried then later to rely on insanity to escape the death penalty, as it was still in force in 1952, he was unsuccessful, and he appealed and was still unsuccessful on that defence. The next slide shows you a number of controversial cases where defendants have been labelled as insane, and it probably surprised you to see some of the conditions deemed to be categorised as diseases of the mind here. So have a read through and highlight the conditions, please. So with the case of Sullivan, we've got epilepsy. With Hennessy, you've got diabetes. And interestingly, the courts have certain views on diabetes because there are a number of different effects of diabetes that a defendant or a person can suffer with. What the courts say is that if you suffer at the time of committing the offence with hyperglycemia, which is high blood sugar, a natural effect of the diabetes, then that would be a condition that gives rise to insanity because it's something that is naturally occurring and therefore naturally likely to reoccur, meaning that you need treatment. But if you're a diabetic and you end up putting yourself in a state of low blood sugar, which is called hypoglycemia, then they actually do not deem that as a natural effect of diabetes and would more likely allow you to rely on automatism instead. And we'll see that in part 2 of our tutorials. There was a case of Quick who was successful in automatism because he was suffering with hypoglycemia at the time, low blood sugar levels instead of high blood sugar levels. I mean, the critics would say, well, surely he needs treatment as well, and therefore insanity should have been the right outcome for him, but the courts disagreed. So those two cases do really give rise to a debate. They are quite controversial. You see the case of Burgess here. This defendant was sleepwalking at the time of the serious attack on his girlfriend with an ashtray, and tried to rely on automatism. Interestingly, at the same time as this, we had the Canadian case of Kenneth Parks going on, where he was raising sleepwalking for committing murder and attempted murder against his wife's parents, so his in-laws, and he was successful. If you remember, we've had a look at that case. Burgess here, who tried to rely on automatism as well, was actually found to have been insane, perhaps on the basis that sleepwalking may be deemed to be a condition that can reoccur. I mean, with Kenneth Parks, the difference was that he was under significant external stresses at the time, financially, physically. So that was unlikely to reoccur again, and we haven't heard of anything happening again. But certainly Burgess, his condition was deemed to have been one that needed treatment. You've got the case of Bratty against Attorney General for Northern Ireland, so quite a really significant case there, led by the Attorney General. And in that case, where Lord Denning sat, in actual fact, there was a distinction between insanity and automatism given and read out. So we'll come to that in part two. But this was again another example of epilepsy. And then if you look at the bottom point, sexsomnia. So this is a condition essentially where kind of overlaps with sleepwalking, I suppose, but defendants are caught having sex with a victim whilst asleep. Now, there are few reported cases here, but I've attached an article for you to just have a look at, where an attacker essentially walked free, was found to be insane, but certainly wasn't given any detention for treatment. And he was at a party with friends. The victim was asleep next to her husband at this house, and woke up to find the defendant on top of her having sex with her. And he claimed that he was asleep, and his wife gave evidence to corroborate his account. He had done that in the past, and the victim herself kind of claimed that he had a vacant look on his face, appearing that he wasn't really fully with it at the time. So quite a controversial area that we will revisit a bit later, but these are some of the cases that have given rise to insanity. What do these cases have in common? The delusional states, epilepsy, sleepwalking, symptoms caused by diabetes. These are all considered to have been caused by internal factors, therefore reoccurring or likely to reoccur, and according to judges like Denning in the 60s, in the case of Bratty, making the defendant a potential danger to the public. They are likely to reoffend again unless they are given treatment. And that's why, if a court believes that and makes that finding, they are likely to label the defendant as insane and detain them, or since 1991, give them a treatment order in the community, rather than allowing a full acquittal under the automatism defence. Okay, so if found insane, completely special verdict here that we looked at in the beginning, the not guilty by reason of insanity. You're looking at, if you commit murder, indefinite hospitalisation, and that is absolutely still in place. And then if you commit any other offence, you could be subject to a treatment order, a period of hospitalisation, supervision, or guardianship. It might be that a court have placed you in the care of a particular person who has legal responsibility for you. Supervision might be run by the probation service or another mental health treatment service. All of this is covered now under the DVCA 2004, which stands for Domestic Violence, Crime and Victims Act. So that's the latest. Remember, in a scenario, you don't need to advise on the treatment or hospitalisation. You can make reference to it, but I really wouldn't spend a lot of time thinking about what a defendant might be given at the end. Your scenarios are all about liability. So let's have a look at a short scenario from OCR. So please pause and have a moment to read this. The question is about advising Jamila, who's committed a number of offences here, whether any defences apply to her. So hopefully, once you've read it, which please do pause if you haven't done so already, she has committed an offence against Ken and an offence against Ken's wife. So she's broken Ken's hip, and Ken is an elderly man, so we could hopefully identify that this would probably be charged as a grievous bodily harm, serious injury, because he's elderly. Could use the case of Bonham. Elderly people are going to be more vulnerable victims. And Ken's wife Iris suffers a heart attack. So again, this would be a serious injury, grievous bodily harm. She took many weeks to recover from it. So Jamila has committed these crimes where she is lashing out at anybody nearby. So this is probably going to be section 20 for both. She doesn't appear to have intention to cause Ken and Iris specific serious injury. So this is probably going to be 2 counts of grievous bodily harm on the basis of intent or recklessness to cause some harm. So that's her liability, but she suffers from paranoid schizophrenia. And she believes that people are intending to harm her. So we could identify that perhaps she could rely on insanity and be deemed to be not fit to be criminally tried, therefore not guilty by reason of insanity. So we have to determine whether she's suffering from a defect of reason. Does she have powers to reason at that time? It doesn't seem that she does. She believes people are intending to harm her. She's got a disease of the mind. She suffers from paranoid schizophrenia, so we can assume that that would be evidenced in court. Does she understand the nature of her actions, or if she does understand what she's doing is legally wrong? If she does understand the nature of her actions by panicking and lashing out, if she believes that people are intending to harm her, then potentially she doesn't understand what she's doing is legally wrong, because she would probably, to a certain extent, believe that she is protecting herself. So she's likely to be successful in this defence. And just note at the bottom, although I haven't asked you to consider this, somebody called Leah intervenes and throws Jamila to the ground, splitting her lip, which bled heavily. So the heavy bleeding would probably give rise to a wounding committed by Leah. But what defence? Have a think about what defence Leah could raise. Why has she caused or inflicted wounding on Jamila? What's the purpose behind it? Why did she intervene? She could raise a potential defence here. Hopefully you determine that she's either defending another, so Ken and Iris, or acting to prevent crime, and she could probably have a defence to that injury there. Okay, so I hope that you found this useful, and in the next part we're going to be looking at automatism, but I just wanted to show you this diagram before I end this session. Essentially, as I said at the beginning, insanity and automatism are both linked in a way. Their technical terms are, in fact, insane automatism and non-insane automatism. Both arise from involuntary actions, you, as a defendant, do not know what you're doing at the time. But the difference ends there. Insanity, by Lord Denning in particular, is deemed to have been caused by an internal factor, a condition that is likely to reoccur, whereas automatism would give rise to external factors, conditions or traumas or something that isn't likely to reoccur, therefore giving you a complete acquittal. So it'll be useful to use this diagram here to just annotate it and make sure that you understand the differences. We'll certainly come to that in class. I hope you found this useful. Thank you.